state intends to question you. Are you going to answer any of those questions? Are you going to testify in this case?
Well, Yana, I've been pressured from the get go. You know what I mean? Like, even when I went to the meeting with Glanville, I have told him over and over and over and over. You know what I mean? This is on my conscience. I got to keep distracting myself every day because I've been dragged down to here because of lies that I don't told. I'm tired of y'all bothering me.
Okay, well, I'm sorry that you're tired of being bothered, but you're under subpoena. It's a valid court order. So your decision at this point is, yes, I will abide by the subpoena and testify, or no, I will not abide by the subpoena and the immunity order, and I will be held in contempt for my refusal and put in jail. So which is your decision?
My bad, guys. Go
Bye.
back. About to go back for you.
Answer to their questions or any other questions against you. And you have been instructed with the benefit of counsel as to the consequences if you don't testify. So I'm asking you now what your intention is.
May I speak?
You can answer my question, please. And so you're under subpoena. The state intends to question you. Are you going to answer any of those questions? Are you going to testify in this case?
Well, Yana, I've been pressured from the get go. You know what I mean? Like, even when I went to the meeting with Glanville, I have told him over and over and over and over. You know what I mean? This is on my conscience. I got to keep distracting myself every day because I've been dragged down to here because of lies that I don't told. I'm tired of y'all bothering me.
Okay, well, I'm sorry that you're tired of being bothered, but you're under subpoena. It's a valid court order. So your decision at this point is, yes, I will abide by the subpoena and testify, or no, I will not abide by the subpoena and the immunity order, and I will be held in contempt for my refusal and put in jail. So which is your decision?
But I did the time for all my crimes that I was caught for.
Sure, this would not be any kind of punishment for any crimes you may or may not have committed. This would be that you have been ordered by a court to testify, and if you refuse to testify, you're held in contempt. You're saying, I refuse to listen to the court's order and obey it. And it is not a punishment, it is an incentive to have you change your mind and obey the court order. So which is your decision?
Can you explain it to me?
So we talked about it.
It's the same thing that Glanville doing to me?
It is the same order that is still in control. You have a subpoena for your testimony. That is a court order. You also have a court order that says anything that you say can't be used against you, other than if you get on the stand and lie and it amounts to perjury, you can be charged with that or with false statements. But if you refuse to testify altogether, when you're under a court order to do that, then that is considered contempt because you're saying, I don't care what the court has ordered, I'm not going to do it, and then you'll be put in jail through the end of this trial.
So
or until you decide, you know what, I think I will testify after all.
So let me, Yana, I'm telling you to your face, you just said that something about it, they can lock me up for lying. I'm telling you to your face, this is all I do. And you're telling me that they can lock me up if I lie. But if I sit here and testify, so the E-way going to jail.
No, not with regard to anything that you might testify to that might otherwise admit to a crime or admit to your involvement in a crime. That's what the immunity order does. And I'm sure Mr. Melnick has explained this to you, and I know I've explained it previously. But none of that is going to result in you being put in jail because they cannot use that evidence against you to prove any of those crimes that you might incriminate yourself about. So are you going to testify or not? Do you want to talk to Mr. Melnick again? Okay.
All right.
Okay. All right, thank you. All right, so I'm gonna have you step out for just a minute while we get the jury in. Mr. Melnick, if you could step out with him, please. Just so. Thank you. Yes, ma'am. I am. I was gonna see if anybody had anything to say first.
This trial based on coercion by Judge Landau. He would be incarcerated forever. Outside to testify. I think at this point, it demonstrates the coercion by Judge Landau, so I'd like you to reconsider that.
I don't think it just demonstrates anything of the sort. I think it demonstrates that he's now been properly advised and he's making that decision anew. Thank you. Overruled. Yes.
Housekeeping matter, is the Harvey rule still under your
Yes.
guidance, still in
Yes,
effect? Okay,
yes, it is.
Thank you.
Okay, and so I'm gonna have the jury out, I'm gonna give them the 3 instructions that we just discussed. Then we'll have Mr. Copeland in, I'd like him re-sworn, and then you can pick up from whatever you want to do post 3 p.m. June 12th.
And Your Honor, may I just step outside to see Mr. Melnick has informed Mr. Copeland that there's gonna be some testimony he's gonna have to repeat. My interactions with Mr. Copeland, he'll get frustrated.
Okay, you know what, why don't you, instead of you going to talk to anybody, just can I have Mr. Melnick in again real fast? That's a good idea, though, to tell him that. I don't know if he's been told that or not. I don't think Mr. Melnick was in here this morning when we were discussing the directions or the instructions. Certainly. Mr. Melnick, I just wanted to make sure, because you weren't in here this morning when we were discussing it, and you may or may not have been in here for any of the times we were discussing it, but we are going to be essentially redoing everything post-recusal motion, and I didn't know if Mr. Copeland was aware of that or not, so some of the things he's gonna feel like, man, I already said this once, but he's gonna have to say it again, because I'm telling the jury disregard a lot of the last few days of his testimony. Okay. Okay, all right, I appreciate it. Thank you. And- Yes. If he's still under oath, that's fine. Okay, yeah, since we are accepting the first part of his testimony, anyway, sure, I'll do that. Anything else before we bring the jury in? Okay, let's go ahead and get the jury. seated. Ladies and gentlemen of the jury, good morning. My name is Judge Paige Reese Whitaker. Judge Earl Glanville is no longer the judge presiding over this case. I will be the presiding judge in this case moving forward, and you are not to concern yourselves with this change. Let me remind you, as I assume the presiding duties in this case, that none of my decisions and nothing that I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in this case. The court is only interested in seeing that this case is tried fairly, based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville that may have been disparaging of any of the lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide this case based only on the evidence admitted during this trial and the law as I will explain it to you. Now, I know that you have been on a bit of a break, but prior to that break, witness Kenneth Copeland was testifying. I'm going to instruct you and admonish you now that you are to disregard any and all of Mr. Copeland's testimony and any evidence introduced during that testimony that came after the 3 p.m. break on Wednesday, June 12th, which was the last break for that day. And that is, you are to disregard any and all testimony and evidence that came after the questioning and answers about Mr. Copeland's involvement in the Atlanta Blood Gang, ABG, and his January 11th, 2015 interview with Detective Thorpe of the Atlanta Police Department. The court is going to be collecting any of the notes you wrote during that portion of the trial, and I'm going to give you a short break in just a moment to identify those notes and provide those notes to my staff attorney, Ms. Persifield. And I'd like to find out at this point in time if there are any of you who cannot set aside and disregard that portion that I just mentioned of Mr. Copeland's testimony and evidence in the deliberations in this case. That is everything after his testimony about ABG and after the 3 p.m. break on Wednesday, June 12th. If there is anybody who cannot set aside and completely disregard that portion of the evidence in your deliberations, please stand up now and let me know if there are any of you. All right, thank you. Okay, so I'm going to give you a quick break to go back in and identify that portion of your notes and provide them to the staff attorney. And then I'll have you back out. I'll give you some other short instructions and we'll resume the testimony. So y'all can go ahead and do that for now for me. Thank you. Be seated. And while they're out doing that, let me just ask y'all what was the practice with regard to order of cross-examination? Is somebody just taking it as the team? Somebody will handle it? Okay. All right. Like, is there going to be one of you fine lawyers who's going to represent the questioning for all of the different defendants, or are we doing all 6 of you individually? Okay, what order are y'all going in is what I was trying to. Okay. Just find out from each of you whether you have anything else. Okay. You may, but I'm not going to wait for you to get back. We would agree that. Okay. we'll just recess in place at this point until the jury is finished with their note. That the jurors, being good stewards of the environment, are taking double-sided notes. So it may be that something has to be erased from the first side, but they need it for the other side. So it's gonna take just a minute, because they're gonna have to make, take it, make copies and give back to them the parts that they can continue to utilize. So in the meantime, I believe Miss DeWilliams, you filed a Jackson demo about some statements by Mr. Ryan, so we'll probably deal with that during our non-jury week next week. Really, that should have been filed by whatever date that was I gave you about 3 weeks ago. When I first took over this case, no reason it could have been filed then. And also, you are essentially just very broadly saying voluntariness, Miranda, and I need some specifics if we're gonna actually. Okay, so you need to particularize that motion. All right, next. The motion in limine 49 now supplemented that had to do with that PowerPoint presentation with one of the gang experts. Can one of y'all speak to that? I know Ms. Love's out of the room. It had appeared that there was an agreement that the state was not going to use that, but then it looked like nothing ever got reduced to writing as an order to that effect. What's the state's intention with regard to either version of that PowerPoint? Because if you're not going to use it, then I don't need to make a decision. And if a decision already got made, then y'all need to acknowledge that as well.
You're right, I think we were trying to check whether or not there was an agreement made before we announced it, so we had.
Mr. Steele cited you to, page and verse, so it shouldn't take much more than that.
Sorry, Your Honor, I'm stepping in because I did not see Mr. Steele's motion, so we did it once.
That was filed on Friday, the supplement. So I need an answer to that. We can circle back on that at the end of the day. Just trying to do some housekeeping while we have time anyway.
Your Honor, speaking about housekeeping, do we have the evidence downstairs for the case?
It's somewhere. If y'all need it,
We need the evidence, Your Honor.
okay, then we'll have to go retrieve it.
Thank you.
I'm about to end this live, guys. Thanks for watching. When they come back, I